Good day, my name is Chris McArdle from McArdle Legal in Sydney. This is a CLE stroke CPD presentation on employment law, and the subject I thought we'd talk about today is what 3 out of 4 people bring up with me, and that is constructive dismissal. People come in and say, my uncle thinks this is a constructive dismissal, or I've just been accused of committing constructive dismissal on someone. It's, for some reason or other, everything's constructive dismissal, and sometimes that's interpreted by people as being a circumstance whereby, say, they get sacked on the spot spuriously for having done nothing wrong, so they say. Sometimes it proves that's a very generous interpretation of what happened, that they've done nothing wrong, but they say it's a constructive dismissal. What I would have thought a constructive dismissal is somewhat more oblique than that. So I don't know why it's such a popular turn of phrase, but it is. So let's just talk about some of the case law on that and whether or not there is such a thing. Let's start with section 386 of the Fair Work Act, which I read. Meaning of dismissed. What does dismissed mean? A person has been dismissed if A or B. A, the person's employment with his or her employer has been terminated on the employer's initiative. It could still be, by the way, constructive dismissal on that definition, but let's talk about that. Or the person has resigned from his or her employment but was forced to do so because of conduct or a course of conduct engaged in by his or her employer. Now, at common law, it's entirely possible that constructive dismissal still doesn't apply to that, because a course of conduct whereby you resign, well, you resigned. But it is made wide enough to ensure that if, in fact, in all but the words, a person's been terminated at the initiative of the employer, which is dismissed, then resignation because of intolerable conduct is sufficient. The term dismissed means termination of employment and it wasn't my idea. Now, if that's because of a series of events or because of you are sacked, therefore you're terminated, then it's still dismissal. But the series of events is what constructive dismissal is. It's not resignation because you don't like it. Now, there's been quite a little bit of discussion about this because people are always bringing it up. Now, section 386 is taking on a statutory basis the common law and making it applicable in a way that doesn't mean that it's super difficult to prove or jurisdictionally or adversarially complicate things more than they should be. So a dismissal has to be at the initiative of the employer. The best example and the most blatant is what I often like to tell clients is that excellent piece of legal research, The Godfather by Mario Puzo, where a person was given an offer he couldn't refuse, and that is he either signed a contract or he would be shot. It's more graphic than that, but he either signed a contract or he would be sacked. An offer he couldn't refuse. Now, if someone says, you sign this resignation letter or I will sack you, then that is constructive dismissal. It's the circumstances mean you're going to get sacked. It's not I didn't like it and I was unhappy. Now, what are the cases on this? There's a case called Koutalis versus Pollitt, and it's Federal Court of Australia, Rare is J, NSD 691 of 2015, and he was considering there whether a resignation offered in the context of a dispute was in fact a dismissal. His Honour found that the applicant, given against the applicant, in other words, he found that it really was a resignation, but it's very useful to look at the underpinning authorities. Now, resignation, His Honour was referring to whether Mr. Pollitt resigned or not. The question whether a resignation did or did not occur does not depend upon the parties' subjective intentions or understandings. In other words, if you think I had no choice, that's right, you think that. Or if the employer thinks you resigned, great, the employer thinks that. It really is something more obvious and more routine on a legal sense than that. Rather, it depends on what a reasonable person in the position of the parties would have understood what was the objective position immediately after Mr. Pollitt left the Koutoulis' business. In other words, whose idea was it to terminate the employment. In that case, the fellow concerned walked across the road and said, well, I'm never working there again, I left. But His Honour looks at the contractual interpretation authority of Alpha Farm Proprietary Limited, and that's a 2004 case, where the full court of the High Court, Gleeson, Gummo, Hayne, Callanan and Hayden, say this: the meaning of the word, the meaning of the terms of a contractual document is to be determined by what a reasonable person would have understood them to mean. That normally requires consideration not only of the text, but also of the surrounding circumstances known to the parties and the purpose and object of the transaction. In other words, what happened is not judged simply on its moment, and what was written is not judged simply on what was written, but on the surrounding circumstances of the matter. Now, in this case of Koutalis and Pollitt, one gentleman was having an argument with his employer and quit in a huff. He didn't have to, and he probably wouldn't have. But then His Honour goes on, Justice Rares goes on, having quoted the High Court. In my opinion, the same considerations apply to the evaluation of the circumstances where parties engage in conversations and conduct that affects their legal rights under a contract, including the assessment of whether or not words or conduct can be seen to amount to a resignation. So what did happen in all of the circumstances? Was it really a resignation, or was it a dismissal? In fact, constructively. In employment context, the court must be conscious that situations can arise in which one or the other of the parties acts in the heat of the moment, in such a way that a reasonable person in the position of the parties, in all the circumstances, would not understand the employee to be resigning or the employer to be terminating the employer's employment, as the case may be. So what would that proverbial reasonable individual sitting on the fence post watching think was taking place? And that's the test: constructive dismissal. Then there's another case referred to by His Honour, which is Sovereign House Security. It's from the old Industrial Relations Court of Australia. It says, in some cases there may be something in the context of the exchange between the employer and the employee, or in the circumstances of the employee, him or herself, to entitle the tribunal of fact to conclude that, notwithstanding the appearances, there was no real resignation, despite what it might appear to be at first sight. So therefore, in advising clients on whether or not they resigned or their employee resigned, but some court somewhere is going to find that they were actually sacked, we really have to, it's not simply a matter of reading the paperwork, it's not simply a matter of analysing the emotions of the client, it's a question of looking at all of the circumstances surrounding the event. Who said what led up to it, who wrote what happened after it. And His Honour says, the consideration also bears on the question of whether, in the circumstances, Mr. Pollitt had been constructively dismissed within the meaning of section 3861B of the Act, which I've referred to. That provided that a person will have been dismissed if he or she resigned, but was forced to do so, and so on. That what happened, he says this, was what happened was set out in substance in the evidence of both the employer and his wife. That is because immediately after the conversation, he went across the road and confirmed that he'd resigned to a third party. And the third party was then called, and the third party satisfied His Honour that this gentleman had decided over the previous 2 weeks to leave, to start up his own business, and that he'd had enough of dealing with them. So what occurred, it was not, I guess, a situation of constructive dismissal, because that fellow, although he had an argument and said, all right, then I'm off, I've had it, it's intolerable, I can't do it. That's what he said, and that's what he claimed. But if we drill down and we look at the circumstances, and we know that he was wrong, and that did not take place. Now, that is underpinned by the basic case. Another case that is O'Mara versus Stanley Works Proprietary Limited, which I'll read out. There must be some action on the part of the employer which is either intended to bring the employment to an end or has the probable result of bringing the employment relationship to an end. So we see that dismissal means termination at the initiative of the employer. So when we're looking at what the surrounding circumstances of the matter are, then what we have, what we need is to assess who says what with the investigative light switched on, that we have to see how that indicates that the actions of the employer express an intention to bring the relationship to an end. In O'Mara it goes on, it is not simply a question of whether the act of the employer resulted directly or consequentially in the termination of the employment. In other words, there was an outburst, the employer was acting unreasonably, you were upset, this was just not acceptable, but it's not enough to say that that led to the dismissal. It has to be whether or not there was intention or the reckless disregard, if you like. The intention was to end the employment relationship, or the action was carried on with the view that the consequence of termination could have occurred and you didn't care. Now, decisions which adopt the formulation of the reasons should be treated with some caution. That is, that it was a consequence of a confrontation. In determining whether a termination was at the initiative of the employer, an objective analysis of the employer's conduct is required to determine whether it was of such a nature that resignation was the probable result, or that the appellant had no effective or real choice but to resign. Okay? No effective or real choice but to resign. If you resign and you say you're sacked, or your employee resigns and says they were sacked, then the onus is on them to prove that they had no alternative. And the alternative, the obvious no alternative, is that you give them a resignation letter to sign, and if they don't sign it, you're going to sack them. Well, that's obvious. But if, say, you're a solicitor and your employer says change the words in an affidavit after it's been executed, and you refuse, and he says either you do that or you have to leave, so you say I quit, well, that's obviously a constructive dismissal. Or something, that's probably an extreme example, but it has to be the employer intended it, or the employer knew it would probably happen and still didn't change what they were doing, knowing that it was going to lead to it. Now, in the one case that we're aware of, an employer was brought into a meeting with some people who set up, his contention was, in order to sack him, to say, you did this, what have you got to say for yourself? Unless you respond, we're going to terminate you. Or at least give you a few days to give us a show cause why we shouldn't terminate you. And this fellow got in a huff and quit. Now, jury's still out on that one, but what does that mean? And there was a case referred to in that context called, that's not as well known as the others, it's Allison versus Bega Valley Council, 1995, in the New South Wales Industrial Relations Commission, and I'll give the citation there. It's matter number 175, and it's that would be in the law reports, 1st of September 1995, and the matter is number IRC 1166 of 1995, and the bench was Peterson J, Marks J, and Connor C. They quoted His Honour Justice Mackin, who went on to become the author of the book. Just as it is a fundamental requirement for an employment contract to be entered into by the genuine consent of both parties to the contract, a consent untainted by any hint of pressure or threat, so too it must be terminated by a resignation equally untainted by any such threat. So coming in, it has to be a free exercise of choice to enter into an employment relationship. To end it and not call it a dismissal, there has to be a free exercise of choice by the employee and untainted by threat. Where a contract is terminated, otherwise it amounts to, and the words are used, constructive dismissal. There are, however, even more compelling circumstances, that's after the end of the quote of His Honour, the bench goes back to, more compelling circumstances why, in our opinion, on analysis, Mr Allison was dismissed by the council. It will be remembered that Mr Allison asked the General Manager do you want me to resign? He asked him that. The question was directed to what the employer wanted. Do you want my resignation? In signifying assent, the employer was in fact indicating to Mr. Allison that it wanted him to resign, that is, that it desired that the contract of employment be brought to an end. Then the behaviour of this was 1995, but the authorities show that this was still the obvious even then. The subsequent behaviour of the employer in pursuing the letter of resignation from Mr. Allison is consistent with the employer's desire to bring about a termination of the contract of employment with him. In reality and in effect, the combined circumstances of the threat to call in the police, what the background of that case, we understand it was some suggestion of malfeasance in the administration of a Shire council, and this gentleman was confronted with an accusation that he had something to do with it, which he obviously denied, and then claimed to have been improperly dismissed, but they said he resigned. The combined circumstances of the threat to call in the police, the request for Mr. Allison's resignation, and the subsequent insistence that the resignation be forthcoming can result in only the conclusion that the real and effective cause of the termination of Mr. Allison's employment was the conduct of the employer. That is, that Mr. Allison was dismissed by the council. So when you get cases where someone says Jim's threatening to resign, and the reaction is, well, go and get it in writing, get it off him, get him to write it down before anything else. Well, that's probably useful. It's useful to punctuate the ending of the relationship, but it doesn't end there. If circumstances such as this arise, where he's threatened to resign and you say, well, okay, I'm going to, you don't try to talk him out of it, you don't say, that's a matter for you, you're not sacked or something like that. But you say, okay then, if you want to, and then go and get him a letter, get him to sign it, etc. The point there is, they made it very clear they wanted him to resign. They said if he didn't, they'd call in the police in that case. In reality and in effect, the combined circumstances are what they are, and the conclusion that the real effective cause was termination. Therefore, is the resignation giving the employer what they want? And what they want has to be made clear on the circumstances, with their behaviour, with their words and deeds, as to whether or not they want the resignation. It's not enough to welcome a resignation. It's not enough to sit and wait and see what's going to happen and then say, well, that's great. Well, maybe that is great, but if it's not the doing of the employer in all of the circumstances, it's not dismissal. A constructive dismissal is when you look at all of the circumstances and it is the doing of the employer, after you've looked at those circumstances, then it's a dismissal. And that's been made a little bit broader in the unfair dismissal jurisdiction, although not at common law. In the unfair dismissal jurisdiction is what we've read out, section 3861B. That is, there is a resignation, but forced to do so. So the employer could say, well, you are not sacked. There's probably a very small difference, but it is nevertheless a difference. That the employer doesn't want you sacked, but the employer is making it so difficult for you that you, being a reasonable person, you must leave. Now, so it must be at the employer's initiative. It must directly and consequentially result in the termination of the employment. And had the employer not taken the action, the employee would have remained employed. So if it hadn't been for the actions of the employer, the employee would have remained employed. It's probably very difficult to generalise in that respect. That's what you have to look at. Those are the two questions that you have to ask. Is there a direct and consequential result? In other words, something the employer did has caused the termination, and had the employer not taken whatever that was, that action, or done that thing, or exercised that attitude, or produced that document, then the employee would have remained employed. There must be actions by the employer. And it's they caused it is not enough. It has to be their idea, their doing. It's you made it unacceptable and you made it unhappy here, and that's your fault. But nevertheless, the person had a choice of battling on. Then that's not constructive dismissal. It has to be, had it not been for them doing something, the person would have remained employed. Then, so there's a number of authorities to then look at, and here's some examples. And I might say just merely from the bench book, but it's all consistent and it's all topical. Here's a case where the employee had submitted a letter of resignation which effectively gave 7 months' notice. Right, so they resigned. The employer purported to accept the resignation but made it effective immediately. So that person was therefore sacked. And that's Nora versus Target Australia. They said, I'm going to leave, and I'm telling you I'm going to leave at the end of the year. I said, well, that's fine, but now, go now. In other words, I'm going to leave, I'm telling you that, just to be gallant, and therefore I'm going to get another, 6 months' pay, because I'm going to stay working for you. And they say, no, that's no good. Leave now, and here's, 3 weeks' pay. Well, that person had been sacked, and there was a remedy for them in the unfair dismissal jurisdiction, and there probably would have been at contract law, other things being equal as well, so long as there wasn't a written and express term of termination of contract. Then abandonment of employment. Here is a person who said that they were unable to attend because they were sick. Well, so long as the definitions of short-term absence due to illness are satisfied, and that is the person had available sick leave, the person had not exhausted their paid sick leave until, personal leave it's now called, I forgot the name of it, sick leave, personal leave, until therefore had been on unpaid leave for 3 months. You could then terminate them because they were unwell and unlikely to come back, and that's the definition. So long as the person had not done that, and they said they couldn't attend work due to medical reasons, well, the person said, I can't come back. Well, then they sacked them. Well, if the person said, I can't come back, then unless they're saying, I am leaving the employment, what this person has said is, I can't come back until I'm better. Well, that's not good enough for me. I'm sacking you, and you've told me you're not going to come back, and you're not going to tell me when you're going to come back, so you've abandoned your employment. No, no, no. That person was terminated at your initiative. They should have stayed on the books until they got better, or until the terms of the Act had been satisfied. That is, ran out of sick leave, then wait 3 months. But they didn't do that. They sacked them. Employer proposed changed working conditions to accommodate pregnancy. So the employer in this case, the person was pregnant. In this case, the employee agreed to work in a less difficult role, but the employer informed the employee there would be significant reduction in salary, which is not actually a safe job. If it's cuts your pay, the employee refused to agree to that and then left. Well, that's intolerable. That's not a job at all. If someone says, good news, you keep your title, the bad news is we cut your pay in half, then that would be constructive dismissal. Your job's gone, and your only remedy is to accept half a job. Then a suggestion that a person left voluntarily and refused to return, that's the applicant disagreed with the employer regarding an alleged non-compliance certificate for one of the workers. The applicant was concerned with her statutory obligations to the licensing authority. The employer overruled her, saying the certificate was acceptable. When the applicant refused to work on the same shift as the worker, she was told that her position would no longer be available as the day shift was finishing. The applicant was offered some work by another employee. However, at no stage did the employer confirm the offer. This was found to constitute a termination at the initiative of the employer. Well, in that case, you can work here as long as you like, but you have to accommodate my unacceptable behaviour with our relations with external certifying authorities, which probably rendered the individual concerned personally liable in any case. So you refuse to accept a statutory breach as a condition of your employment and leave, then that would be constructive dismissal. The employer put you in an unacceptable position. But it's not an angry position. It's not something that's not for me, that's not how I want to go about it. It has to be a position whereby you'd in effect be breaking the law if you stayed in that case, or you in effect would be compromising your ethics. I'm very wary of that one, because so many people say, oh yes, I'm ethically disinclined to come to work at 9 o'clock every morning or something. So it has to be what the reasonable person would think rendered impossible for the employee to start work. But then very, very common for people to say these things. A person was not renewed at the expiry of a series of fixed-term contracts, and they said, well, they'd been sacked. Well, no, they hadn't. It just came to an end, and we didn't renew. We had the right not to renew. We didn't renew. You agreed, as the words of Mackin, freely entered into an agreement based on certain tenets, and that tenet was fixed term. There will be no more employment after the 31st of July 2016 unless there's a further agreement between the parties, and there was not. That's not the initiative of the employer, that's simply the contract coming to an end. If you're there for years, and this happens a lot, people are on fixed term contracts where they get rolled over and over and over. Well, if at some stage that it's decided and with due warning given that the contract will be honoured, unless you can argue waiver, and in the case here that's quoted in the bench book they couldn't, but unless it's despite the paperwork, your expectation is that you're going to just keep working, then the employer cannot be held to account for taking advantage of a contract, and that's what that one is. If you are on, and this does happen increasingly in the public service, by the way, if you're on a series of fixed-term contracts and once every 18 months or so you just sign up to extend, sign up to extend, sign up to extend, and one day the opportunity to sign up to extend is not presented, then unless there was, or nothing happens, you just keep showing up, then unless some indication took place whereby one party had waived their entitlement to bring something to an end, then you'd probably have constructive dismissal there. We did have a case where we had people in a state public service entity who just kept on getting rolled over, and for a couple of years there was no rollover at all. They just showed up. Well, then the employing authority said that, oh no, come to think of it, we have an entitlement to have brought your employment to an end, and you're actually only been employed week to week, you're a temporary employee, you leave. Well, we were able to settle that one, but I'm convinced that on the basis of Department of Justice versus Lunn, 2006 158 IR 410, it wouldn't be a series of out-of-limit contracts. That would have been, in practice, if it was an out-of-limit contract in writing, then the entitlements under it were waived when the person was not dismissed when it ended, and therefore it became an indefinite contract subject to termination on reasonable notice, but in this case also subject to the unfair dismissal jurisdiction. There's apprenticeship contracts, they come to an end where the employer says, well, you're sacked because your apprenticeship's over. There's been a long tradition for many years in many industries where when you finish your apprenticeship you leave. And that's for two reasons. One is that's to stop people starting somewhere at 15 and for some reason just staying there till they're 70, 75. I have had a case of that. The idea is that you go out into the world and you get experience, and there's something in that, and also you create a spot for the next lad to come on or lass to come on. So the idea that an employer terminates you when you finish your apprenticeship, even so long as it's not a surprise, so long as that's the tradition in that place of work, and so long as you know in advance that it's going to happen, then it's not at the initiative of the employer. That's the freely entered into agreement between the parties. Now, that's all the questions. These are the circumstances that might have been or might not. But then the Marlon Brando questions. Forced resignation. You sign this or you're sacked. The onus is on the employee to prove that it was a forced resignation, that it wasn't voluntary. You can't just say it, you have to prove it, the P word. That's true at the unfair dismissal in any case. But there has to be no real choice but to resign. So it has to be a forced resignation. Our heat of the moment resignation's no good. That's No NGO versus Link Printing, 1999, 94 IR 375. Has to be a clear and unambiguous resignation. Is a resignation. But if it's given in the heat of the moment or under extreme pressure, then special circumstances may arise. And that's the Sovereign House security case that I referred to before. The employer may be required to allow a reasonable time to pass. So why don't we all calm down? The case I'm thinking of that we were recently involved in, it was a heat of the moment. The fellow became insulted and said, well, if you want, I'll resign. Mind you, it's exactly what they wanted, so they let him do it. But time will tell to see what is the finding of the tribunal I'm thinking of as we speak about what's going to happen with that. Now, the same thing with the individual who came in and gave 6 months' notice, was then sacked on the spot. The employee writes to say that they intend to resign in the future, and it's sent at a time that the employee was distressed and unwell and held not to be effective notice of resignation. Accordingly, the employer's purported acceptance of the resignation was held to constitute a termination of employment of the employer's initiative. What happened in that case, Marks versus Melbourne Health, was that, and that's a case from 2011, what that means is that if the employer takes advantage, someone's in a state of distress and says, well, I resign, I can't take this anymore, you know that that person is in a state of distress. You know that the stable them wouldn't go along with the unstable and unhappy them, but you accept the resignation in any case. Well, that's constructive dismissal. It's not a legitimate. It's not a legitimate resignation, and it's forced by circumstance. Now, what if a person keeps showing up? I've actually had this happen. It's a dreadful case, but I was sent to terminate someone, and did, and that was that. And I found out 3 months later that he'd ignored me. But this person was the only representative in Sydney of this organisation, so they sent a lawyer to do this nasty bidding, which was rather, in my view, unsuitable for them. They owed it to their employee to face him. But so we went along, we said that, we're very, very sorry to hear about this, and left. And found out from the client 3 months later that this person had been continuing to show up, continuing to do his job, and continuing to draw a salary. Well, had that person been sacked, had that person effectively resigned? Well, that's taken up in this case, Bender versus Raplow. After an angry discussion between an employee and her manager, the employee believed she had been dismissed and the employer believed that the employee had resigned. The employee continued to attend for work afterwards in the belief that she had to work out the notice period for her dismissal. The employee was found not to have resigned because she did not demonstrate any intention not to be bound by her contract of employment. So that person showed up, didn't take time in lieu, didn't accept on-the-spot termination, just continued to work. It was probably, had the employer said, no, you can't come in, you've resigned, you don't work here anymore, we have decided to pay you out in lieu of notice, then it would have been a different matter. But same thing in the case I'm talking about. We didn't know the person had been turning up, and the offshore client didn't know the person had been turning up, but the person had continued to get paid. Now, that was a supervision issue on the part of the client. They paid. So there was an implied term there that the person had not been terminated but was continuing to work and had not resigned. Failure to pay wages, you can't resign because someone's not paying you and then say you haven't, then the employer say you haven't really resigned because you haven't really been dismissed, you really resigned of your own free will, but it's not of your own free will. For one thing, there's a repudiation there. The employee agrees to be employed and the employer agrees to pay. Well, if you're not paying and the employee leaves, albeit by resigning, then it's still a dismissal and you'd have to pay compensation. You'd also have to pay, at common law, reasonable notice and payment up to the day of termination as well. But there are other cases where people walking out in a huff doesn't work. A person was subjected to a disciplinary interview and then left. Well, I simply said, you're on performance management, we're going to be monitoring your performance, we expect you to meet certain reasonable standards, and they don't, well, that employee is not terminated even though they resign. You'd wonder why that case was commenced at all. In a jurisdiction where costs could be claimed, that person would no doubt have had costs awarded against them. There was a person suspended and resigned they were suspended from barred access from the workplace and subject to a disciplinary investigation, but they resigned. They should have waited out the disciplinary investigation, because if they say if they were going to get sacked after the disciplinary investigation, then they would have been sacked, but they might not have been. So they had a choice. If there's no choice, then it's termination. The employee negotiating conditions following change in position. The employee resigned in the belief that her employer required her to accept a lower rate of pay or resign. It was found that the employee had misunderstood the position and acted prematurely because the employer had made no final decision about the matter. The resignation was therefore not forced, so that the person said, I'm thinking about your position, I'm thinking about where we're going to put you, I'm thinking what we're going to do about that. The reaction is, I resign. You could hardly, now it might have well been after the employer had said, I've thought all about it and there's no spot for you, you're cut. The employer might have said, well, I've thought all about it and there is an excellent spot for you, please accept that. You then wouldn't be cut. So something might have happened, you had options. So that employee had options and didn't take them. Then performance management plan, probably similar to that previous one, Ashton versus Consumer Action Law Centre. They resigned, having been placed on supervisory requirements. Their termination has not been forced. Then prior to a decision being made following a disciplinary process, the employee was subject to disciplinary procedures, the same as Davidson versus the Commonwealth, acted on the advice of the union and resigned before the employer had come to a decision in relation to the disciplinary matter. This was held to be voluntary, not a forced resignation, as indeed it should, because if the disciplinary procedure is not genuine and it results in your improper termination, then so be it, that you have an entitlement to expect reasonable procedural fairness. But if you preempt that and probably don't give the other fellow an opportunity to do it wrong, then you are exercising a choice, albeit it might have been traumatic. There's also an implied suggestion in all this that if you get out before the finding, then maybe you had some deep-seated suspicion as to what the finding should be rather than what the finding was going to be. But in any case, you are exercising a free choice if you get out before a procedure is over. If you let the procedure run and the procedure's been wrongly handled, for instance, I am aware of a case where a person is engaged in an investigation, but without her realising it, someone else was conducting an investigation without even referring it to her and has made findings about her. So one would have to ask, one of those investigations, the one she knows about or the one she didn't know about, is a sham, and the situation, the outcome is a foregone conclusion in any case. But that person should have waited, and in all of these cases, the person should wait. There's an unfortunate case where, due to cash flow problems and a computer error, the person didn't get their superannuation paid, and their wages were paid a couple of days late. Now, that's unsatisfactory, but they weren't without choice. They could have said, "Where's my pay?" The next one is, have you been terminated if you've been demoted? Well, the answer probably is yes. Depends on what you've been demoted from. If you've been demoted from being an acting number one down to a substantive number two, that's a different matter. But if you've been demoted into what is in effect an unacceptable by any reasonable person, or a job that leaves you considerably worse off, then that is not a contract according to the Macken principle, that you entered into freely with an open mind and without pressure. That's something that you'd have no choice about. You either accept less money or you leave. So is a demotion a termination? Almost certainly yes. A person was going to suffer significant reduction in that case. That's Johnson versus C. Hoot Proprietary Limited. The employee had worked for a clothing retailer for over 12 years in a variety of roles, including National Sales Manager and National Operations Manager. She was asked to manage a store that was performing poorly and agreed on the basis of the maintenance of her then current salary package, so maintenance of income. Within a year, the company sought to have the employee agree to a change in the terms of her contract of employment, equivalent to a reduction of over $30,000 per year. The reason I hesitated then is this is almost all fours with a case we did about 2 years ago, but thankfully not the same thing. I'm not disclosing anyone's confidences here because we settled that one to say you just go along there and everything's going to remain the same, no problem there, and it doesn't remain the same. Your conditions and accruals, etc., are not remaining the same, then that's a different job. It's a lesser job. It leaves a person in a worse off position, and they're not entering into a contract with you free and without pressure. Therefore, they have no choice. If they're to maintain their lifestyle, perhaps continue to pay the mortgage on their house, they have to leave. So that would be a constructive dismissal. Now, a particular period of time, it's almost impossible to say that it's at the initiative of the employer if by mutual agreement where this is going to end. The best example of that is a shearer finishes when all the sheep are shorn, a bricklayer finishes when all the bricks are laid, a builder's labourer finishes when the house is built. If the builder's labourer said, well, hang on a minute, I work for you now, I'm not leaving because you've sacked me and that's at your initiative, well, it's not. It's a fluxion of time. So there's no constructive dismissal in that. I actually have had people do that because they'd been rolled over onto other contracts in the past and they think that should continue in the future. It might have been the case if it had always happened, if a person had been working there for several years and just took it for granted with an expectation of employment that they were going to be rolled over. But if it's clear, freely entered into arrangement, that there's going to be some sort of termination in some way, it cannot be a constructive dismissal. But the exception to that is the contract contained an unqualified right to terminate the employment. It was found that the contract was not for a specified time. And this is a very old one, where a very old stunt and very uninformed one, where people basically have contracts that says, I will do what I like. Well, you might be able to have a contract that says that, but it's not if it's a breach of the statute. And in a particular case where the person wasn't sacked because they had agreed in advance that whatever the employer wanted to do, the employer could do, well, that would be an agreement in advance that the employer could breach Section 387 of the Fair Work Act if the person was earning less than the high income threshold. At the time of speaking, $138,900. So it really does come down to this is probably what we're learning on this point, the underpinning of the contractual entitlement, the circumstances of the matter and the statutory provision. Then the contract expired, the employee was employed on a series of fixed term contracts. There was an acknowledged practice of continuing employment even after a contract expired. They found that she was continuously and not employed continuously and not for a specified period of time. That's what I did say earlier with that public service case. If there's as soon as the finishing date comes and goes, and if you're an employee and you've got a fixed term contract, then the thing to do is wait, because if the employer then says, well, it's over now, but it's 3 months after the fixed term had come and gone, it's over now, you're sacked in accordance with the contract has ceased to apply. So there's no agreement to leave. The agreement to leave was waived. the common law principle of waiver. No one did anything about it. And then there's contracts for specified tasks, which I've mentioned about the laying the bricks and shearing the sheep. There's a traineeship, an apprenticeship. The apprenticeship is a contract of training and a contract of employment, and you can agree that it's going to end, whether the contract of employment is going to end at the end of the contract of training. The person was engaged as a general hand in the vineyard to say, I'm being hypothetical, put up the wire stays for the vines, then finished that and said, okay, what's next? And they said, oh, you were engaged to do that and do that only. Well, they weren't. They were engaged for the purpose of being an ongoing employed labourer. Well, that person probably didn't get much money, but it was still a termination of employment at the initiative of the employer. Points to be taken, and I think the things to be learnt in this are that everybody's going to say constructive dismissal. I don't know why that is. I think it's probably because it sounds good and it sounds educated, that this is a case of constructive dismissal. And what are the circumstances? Well, here's a letter terminating me with 4 weeks' notice, and I reckon it's constructive dismissal. I don't know why people say it, but I was sick of the place. I was sick of what these people were doing. They didn't know what they were doing. They were blithering idiots, so I quit. And now, had they not been them, I wouldn't have quit, so therefore it's constructive dismissal. No. It's the case where, as Mackin says, just as it is a fundamental requirement for an employment contract to be entered into by the genuine consent of both parties to the contract, a consent untainted by any hint of pressure or threat, so too it must be terminated by a resignation equally untainted by any such threat. Where a contract is terminated otherwise, it amounts to constructive dismissal. So if your employee resigns and you made the employee resign because of what you said, what you did, what you wrote, how you acted, then you have sacked the employee. That has repercussions if they don't have a written contract of employment in the Queen Jack Chia area. That is Rankin versus Marine Power International. That is up to 12 months' pay if they don't have a written contract of employment. Definitely comes under section 3861B of the Fair Work Act if you do those things. Now, it's possible, one might say, to have a contract that says I can behave in a way that is arbitrary, offhanded and one-sided, as we find in Silverbrook versus Lindsay, which is a New South Wales Court of Appeal case from January 2010, that in that case there was a discretion as to the payment of bonus, not this area, but they're all about exercise and equitable exercise of discretion, where Justice Allsop said that if there was to be as an implied term, that there will be, if I can interpret his Honour's words, there'll be a reasonable and equitable exercise of a discretion. It won't be an unreasonable one. But if there was going to be an agreement between the parties that the employer could act in a way that was entirely arbitrary, offhanded, bloody-minded and one-sided and at their absolute licence, then it must say so in writing. I've actually seen such a contract since then that the employer can act in any way they choose fit, but very few contracts say things like that. That I can terminate you whenever I like, in whatever way I like, and whatever. If you leave, as they commonly say, if you leave, the only compensation you will ever get is under this contract, and you'll get nothing else. Well, that whacks right up against the Fair Work Act if the person earns less than $138,900, or could we earn lots of money and still be covered by an award. Probably unusual, but we do get cases where people earning $500,000 are covered by an award. If we get back to, I will do what I damn well like, I will behave in a way that gives you no choice, even if it says it in writing that you can do that, very unusual, does happen. If it says that, then the Fair Work Act kicks in, section 3861B, and then you've got to look at section 387. That is valid reason, not harsh, unjust or unreasonable, person was given an opportunity to respond, and so on, section 387. So constructive dismissal, why do people say it? It does happen. It's not nearly as usual as people say, and it's something that's probably not needed to be entertained by practitioners all that often. I hope that's been useful. Thank you very much.